And tonight we are live on the JoyNews channel on Multi TV. Also live on Joy 99.7 FM, live on myjoyonline.com, and a host of social media pages are already having a conversation about this very important discussion. Connecting in the studio shortly will be the chairman of the Constitutional, Legal and Parliamentary Affairs Committee. His committee has been leading the consultations on the Special Prosecutor Bill. Ben Abdullah Banda will connect in the studio very shortly. Also connecting is a ranking member on that same committee, a man known for his strong legal views. Inusaf Husseini connects in the studio here on Ghana Connect. This week they have been involved in a consultation. In fact, they went there to observe, and they are running a social media page, and online they're providing details on a Special Prosecutor Bill. Normally, they scrutinize the work of MPs, ranking them from the best to the worst. Ernest Ama connects in the studio from Odikro. We'll be privileged later on to connect with Professor H. Kwesi Prempeh. You've heard him this week. Very vociferous on this particular bill. We'll also connect to the Deputy Shraj boss, who will join us via Skype. And later we'll connect to the U.S. because the U.S. has a very interesting, long-standing tradition of bringing in independent prosecutors. We are calling our special prosecutors, but there's one right now, Mueller, who is doing a great job at probing the president, Trump. And so we will speak to a lawyer in the U.S. about how their system works and what we can learn and probably incorporate into ours. And understand that the committee will be traveling to, well, North America to consult further. So we will try and get that conversation up going and then see if we can bring that into what we are doing locally. And later on, I will unveil a poll we run on social media just to get a sense of what people are thinking about this. So we asked a simple question. Is the office of the Special Prosecutor one that is a democratic necessity or a needless duplication? And you were supposed to simply answer A, yes, it is a democratic necessity, or B, no, it is a duplication of existing structures. And remember that we are always live on WhatsApp 0244340437, and we are live on Twitter, Ghana Connect, hashtag Ghana Connect Live. You can also obviously get in touch with that on our Facebook pages. Across platforms, your JoyNews page, Joy 99.7 FM. I'll share your thoughts with the rest of the world. And that poll, fascinating outcome there, what people think about the bill that is currently being before the committee, and they're looking into it. So that's for later. I want to come to the studio and start with Inusaf Husseini as we wait for his chairman to join us in the studio very shortly. Mr. Husseini, let me ask you, where are we with the process, in the process?
Well, thank you so very much. I think that I must commend Joy FM and, for organizing this program, because we had said when the bill was first laid in Parliament that the bill was of such an important nature that we needed to engage the public and seek public opinion and views, perspectives on how to fashion out and design an institution that will stand the test of time. I mean, and the celebration of Democracy Day by bringing this topic to the fore for the involvement and discussion of people. It's a feather in the cap, and I commend you for that. Now, we've just finished with the stakeholder consultations, which we held on Tuesday and Wednesday. I mean, very interesting perspectives were given on the bill by different stakeholders. We will be going to Kofredua on the 20th of this month to consider the bill clause by clause. And we hope to finish the consideration of the bill by Saturday or Sunday.
Okay.
Then we prepare ourselves to undertake trips to North Africa, to South Africa, and to Asia, to look at how.
Why are you going there?
It's important to see how the office functions in these respective countries. I mean, there are many important considerations to look at when trying to fashion and design out an institution like the Special Prosecutor. I mean, how is the independence of the Special Prosecutor secured in countries like Canada, in America, in South Africa, in Singapore? I mean, you should know that the decision as to whether or not to prosecute a crime is the cornerstone of any criminal justice system. And why there was a clamor for the establishment of the Office of a Special Prosecutor was that it was believed, it was perceived that the Attorney General by our by the constitutional framework, the governance framework in this country, has the exclusive responsibility for the initiation and conduct of criminal offences. And so the authority of the Attorney General being exclusive and being executive in nature, I mean, it appears that the Attorney General is the only Minister of State who the Constitution carves out some bit of the President's power for him, for the office. And so the only time that an offense, or all offenses in this country, must be instituted in the name of the Republic at the suit of the Attorney General, or by the authority, by authority given to a person to conduct or initiate the suit on behalf of the state. So it means that by law, that should be done by law. It means that the only time somebody can bring or prosecute a criminal offense other than the Attorney General is that that person must be doing it in accordance with law.
That's interesting. Those are, it's interesting that you've laid out where we are and the fact that you're going to be doing a bit more touring. But let me come to the fundamental controversial question that people are split in the middle about. They have those in the middle also, the neutrals. Ernest, let me ask you that question, and then we'll then move on to some of the substance of some of the clauses, because the most important thing we want to do is to go through some of the key clauses, the controversial ones that have come up so far. So where do you stand on that question about whether this is the office is a democratic necessity or a needless duplication? Where do you stand on that? Are you one of those who say this is a democratic necessity or is a duplication?
Well, Evans, at Odikro, what we do is to monitor these processes and inform Ghanaians on these processes as well, to have a glimpse into how bills are translated into laws and how MPs actually work at the committee level. So we have been tracking the process. We participated in the 2-day stakeholder consultation exercise that we organized, and we witnessed the broad recommendations that came from public stakeholders and other individuals who also participated. And you can clearly see that there is a schism between those who are for the bill and those against, because other people make the argument that we already have existing prosecution agencies, and the problem with them has been a matter of resources, has been a matter of executive influence, political intrusion into their activities. And here is the case: we have not properly tackled these issues, and we are moving on to create another prosecution agency without solving these problems. How is that going to play out? So, Evans, to be very honest with you, Odikro, we do not have a position. What I can tell you...
So you are the ones in the middle?
We are in the middle, but this is the position that we have, is how open is the process?
You think it's open?
We feel is open in a limited way. It's restricted. It's not reaching Ghanaians enough. Because when we participate, we realize that the people, of course, they represent sort of a critical mass of Ghanaians. But then we felt that the process could have been extended further, because when Martin Amidu reacted to this bill in the media, most people were quite moved by the submissions made, but most of them have not seen the bill. So people wonder what exactly was Martin Amidu talking about. But Martin Amidu has carved a certain niche for himself, so people believed him. But Ghanaians didn't have access to the document. Honorable member is here. When the process started, I was thinking the document, that's the bill, will be made available online, so that Ghanaians who cannot even participate physically at the stakeholder level, online, can be making contributions. We didn't see that happen. And that sort of limited the process.
You want to respond to that? Because I get the same sense. When we posted the poll, people felt they had no clue what was happening.
Well, I'm surprised, because when the bill was laid, the Parliament, the Office of Parliament had to take steps to put the bill online, because we had come to the decision, and at plenary, that we wanted the bill to go through the normal legislative process. And that meant that making the bill available and inviting stakeholders to participate. And so the stakeholders ought to have been given copies. And the way they will get copies is to put the copies online if they want to download the copies. So, it's taken me aback. But the initial laying of the bill clearly also demonstrated some challenges, because we didn't even have enough copies when we were being invited to consider whether or not to take it through the certificate of agency. So, it's not late. We're still engaging with stakeholders, and And probably when Chairman comes, we'll take steps to get Parliament to put the bill on the website. You need people to contribute to fashion out a bill that clearly will be good for Ghana. But Evans,
Tell me.
It's a democratic necessity.
It is?
Yes, because this is founded. You need a political leader. To challenge the status quo. The MPP had said that judging from the perception of pervasive corruption in the system, then you needed some radical approach to it, and that the institutions of state, which have been charged with the responsibility of fighting corruption, appear not to be doing enough. And the people of Ghana overwhelmingly voted, and they voted in favor of that. So establishing the office becomes a
voted. You're talking about elections.
The elections.
Oh, they voted for Nanado.
Yes.
Because of one of the promises he's made. Okay, so,
Yes,
so
yes.
it's an indirect endorsement.
Yes.
That he wanted.
So it counts as of necessity for the institution to be established if Nanado has to fulfill his electoral promise.
Okay.
So it's a democratic necessity. The people of Ghana exercise their democratic rights to determine whether or not we need a special prosecutor, and they did it overwhelmingly. Whether or not it will be a needless duplication will be the institution that will put in place. Will it fight? Will it meet the legitimate expectations and aspirations of the people of Ghana?
That is a very important point you've made, and we're going to go into detail. I see you are earning to say something. Please go ahead.
because Honourable, the same Ghanaians who voted for the president are asking how distinct the office of the special prosecutor would be, from Hioko, from the Attorney General, from the other prosecution agencies. How different will
all the other agencies are multi-tax. They do many things in addition to fighting corruption. This particular office will have a single tax.
Iyoko all Iyoko does is to fight corruption.
No.
What else does Iyoko do apart from fighting corruption?
Iyoko fights organized and serious crimes.
Such as
money laundering.
But that's corruption.
That's a predicate.
That's
corruption. Corruption is a predicate offense to money laundering.
No, money laundering is corruption. Money laundering is corruption.
Oh, if somebody
if a politician launders money to the US,
if the money
the special prosecutor will
the money is derived through corruption, but if a businessman launders money through dealing in drugs, how does that become corrupt? They're probably corrupting the people's morals, but how does that become corruption of a public office?
So Honourable, what
you understand? So if another person launders money through trafficking in small arms, how does that become? So Iyoko deals with that. It's an organized crime. Okay, that would be an organized crime for Iyoko to deal with and to track the processes and be able to put a stop to, if there's a chain, to put a stop to a chain. That's the difference between Iyoko and Office of Special Prosecutor. He will be prosecuting corruption cases founded on violations of the public procurement law or the offenses in the criminal code.
Yes.
Okay. And we have said that we will disagree in limiting the scope to offenses of corruption that threaten the security of the state. No, we say that they should give, the conference was of the view that the special prosecutor to be appointed should be given the free hand to determine which particular corruption case it wants to pursue. Because petty corruption can lead to the discovery of a chain of corruption activities. And so give the special prosecutor the opportunity to choose. And so this one is going to be single purpose.
And as you're not convinced?
Single purpose vehicle.
No, because Honourable, the Iyoko representative was there at the consultation, and he said that he made the number of submissions that the major constraint with Iyoko's work is resources. So if they have the resources, they can be able to, exercise their mandate.
Say so, not so.
You know what we're going to do? these are preliminary comments about. I guess and it's important, Honorable Yusuf Hussaini, that we're still debating whether this is even necessary, right? That debate is still there. It's boiling.
Evans, it's boiling, but we passed there.
Well, I see
submission that we passed there.
I get the point because the president was voted for.
Yeah.
I get your point.
Yes.
But what we're going to do after a quick break is we're now going to go into the details. And for me, this is where it gets important. Because if you've not had the opportunity to listen to the key aspects of this particular bill, this is your opportunity to do so. And please get to social media and start engaging on WhatsApp, start engaging on Twitter. And I'm going to announce quickly the lines you can get it on, especially on Twitter. Hashtag Ghana Connect Live. WhatsApp 0244340427. And Facebook, Joy 99.7 FM or the Joy News page. Let's bring in your concerns and questions, and we'll put that to the panel of experts. We're going to be joined shortly by the chairman who is here with us. Take a short break. We'll be right back. You're live on Ghana Connect here on Joy 99.7 FM, also on the JoyNews channel on Multi TV. We are debating a central question as far as the Office of the Special Prosecutor is concerned. Remember, consultations are ongoing, and I say this on our Ghana Connect social media pages that get your voice heard or forever hold your peace, because once it's done and they finish the consultations and it's approved by Parliament, it's law. It will be too late for you then to contribute and try and influence that bill. And this is going to be one of the most fundamental, one of the significant acts that Parliament will pass in its history, because we've not had this office before. We're trying this for the very first time, and this is such an important vehicle that you cannot be left out. And so please send us your thoughts, your questions, and we'll put it across to my panel here in the studio. Shortly, we'll be connecting to Professor Kwesi Prempeh. We'll also be speaking to lawyer Nana Kwesi, who believes is a needless duplication. Let me bring in the chairman of the Constitutional, Legal and Parliamentary Affairs Committee, and he's been leading the consultations. Let me ask you that fundamental question we asked in a poll, and we'll announce the poll results very shortly. Is this office a democratic necessity, or is it a needless duplication? Where do you stand on that question?
Okay, first of all, let me say good evening to all your viewers. It's not a needless duplication of institution, apart from the fact that it is a democratic necessity, and the fact that it's a political promise which has to be redeemed. Across the world, in most established countries, some of the reasons that have been assigned for the appointment of independent counsel, as certain countries may choose to call it, or independent prosecutor, is that certain high-profile officials who have close proximity with the Attorney General, if alike, may have the proclivity of influencing the trend of the prosecution. You can talk about the US. For instance, if a cabinet minister is alleged to have involved him or herself in a high-ranking corruption matter, I mean, will it be appropriate, if like, for the Attorney General, who is a member of the cabinet, to prosecute his or her colleague cabinet minister? It will be difficult. It is one of the reasons why, if you go to a country like Canada, in the province of British Columbia, this legal system or legal regime is in place to ensure that certain high-ranking officials are prosecuted not by the country's Attorney General, but by a special prosecutor who is appointed, though by the Assistant Deputy Attorney General. But the issue or the decision to conduct investigations and decisions to prosecute high-ranking public officials rests solely with that special prosecutor. And it's so important that even as we speak, we have one in the US right now actively probing the president and everything else. That's the point. So how do you expect the Attorney General of the United States of America, who is appointed by the president, to prosecute a high-profile if like alleged scandal matter of this nature. It will be difficult. That explains the rationale, the philosophy, and the opinion, the promise made by His Excellency the President to the people of Ghana, that when the people of Ghana elected him into office, he was going to create an office called the Office of the Special Prosecutor to deal solely with the menace of corruption and corruption-related matters. And of course, it is also in tandem and in line with the United Nations Conventions against corruption. It is a global menace, a global, problem that every country, day in, day out, is talking about. So across the world, if you go to Philippines, there's this type of legal system in place where if a public official is involved in corruption or corruption-related matter, a special prosecutor is appointed. It's across the world, South Korea, etc., etc. So it's not a situation exclusive to Ghana. I think we are learning from certain established democracies.
So
or
it
countries.
is a democratic necessity.
There is a necessity.
Okay. I think that is agreed, except for Honest Ennis, who has questions. He's in the middle of that, asking a lot of legitimate questions that a lot of you are asking. And I'll be sharing some of your questions shortly. But let's go into some of the details, shall we? Because that's why we're here. I mean, I want us to get biting into the nitty-gritty of this very quickly. Now, having addressed that, having crossed that, and I like the point that Inusa Fuseni makes about once Nana Addo won the elections, it is an indirect endorsement of that proposal to create that office. So Ghanaians voted for him and expecting him to implement that. And so that debate about whether it's necessary or not, we have crossed that.
We've gone past that stage.
So let's ask. The question then is about what the law you've crafted, the bill you've crafted. Something I saw in the bill, and I've just been reading it today, that we haven't heard much of, is a part of funding. You know, this week, Kwesi Prempeh elucidated on this. It says when we talk about the independence of the office, it has to come, we have to see it in different levels. One, in how we fund it. Two, in the way we appoint it. And so I went to look for these elements, and I went to the funding. Now, I want to read to you, all of you listening and watching on TV. It says that the source of funds for the office includes monies approved by Parliament, donations, grants, gifts, and other monies approved by the minister responsible for finance. In fact, I want to read the relevant clause in the Act. In fact, that's under 20, I think. Is it 20?
21.
21?
Yeah.
Correct. And this is in the bill.
Yeah.
The funds of the office include A, monies approved by Parliament, B, donations, grants, gifts. And I'm asking myself, donations, gifts to the office of the special prosecutor? Aren't you opening the office up to manipulation by corporate interest, corrupt individual interest, who will then use this as a means of pumping their monies in there, especially when they know they're going to be subjects of a probe, and indirectly influence the process? Why was this necessary?
I think that, first of all, this is a provision which is a standard provision in most of the legislations that Parliament has passed. We see this particular provision being crafted the way it has been crafted. So when we did the stakeholder engagement, a lot of concerns were raised with respect to if we want the special prosecutor to be independent, why do we talk about donations?
And
why
gifts.
do we talk about gifts?
We know the problem we have with gifts
Why
in
do
Ghana.
we talk about grant, etc., etc.? So there's a tendency or the proclivity of somebody trying to probably influence the decision-making process of the special prosecutor.
True.
That issue was raised. But there is a caveat.
Okay.
The caveat is that such donations and grants approved by and grants must be approved by the minister responsible for finance.
That's even
So,
worse.
is it
Appointed by the president. That's
Of
even
course.
worse. That is even
Every
worse.
appointment, you see, when I say that, I mean, nobody appoints himself.
Right.
Somebody must appoint somebody. Okay? The president was elected by the people of Ghana. He does have many appointments. Even in the private sector, somebody must appoint somebody. So as for the issue of appointment, I don't see it as a problem.
We'll come to that. It's a substantive point.
So
let's stick to the funding.
By the minister. So it is not every donation, every grant,
Every gift.
or every gift which will be deemed to be accepted or which will be deemed to be clean and accepted by the minister. So it has to be, it has to go through some rigorous process of cross-checking whether the donation, grant, etc. is of a legitimate source.
You just raised another fundamental question. And
So,
I know you have a lot of questions, but let me fire this, and then NS will come in. And please feel free to send us your questions as well.
But let me end by saying, let me just land by saying, or end by saying, this bill is at its incipient stage.
That's not in doubt. Absolutely.
It's at its incipient stage.
So it could change.
That explains the reason why we decided to engage stakeholders
Okay.
to solicit their views and input into the making of the bill and into the passage of the bill into a law. So if at the end of the day, the committee meets with the Attorney General and the committee is of the view that in view of the concerns that have been raised at the stakeholder engagement, we need to delete this provision.
At this point, where do you stand on that? Should we delete it or should we keep it?
stand now.
No,
Let me bring in Mr. Fuseni. Then I'll come to you. Let me bring in Mr. Fuseni.
First of all,
Please, your comment on that.
Your view and your observation is very well founded. In securing the integrity of the office, you must also ensure that the funding regime will not be under the control of somebody. So that person can use it to emasculate the Attorney General's office. And so it's well founded. So even approved by Parliament.
Approved by the minister?
No, the first part. The money is approved by Parliament.
Okay.
How do we ensure that the money required by the special prosecutor is captured in the budget to be presented by Parliament? Okay, because Parliament Sumutu, except where in the matter of the judiciary, Parliament Sumutu cannot allocate. Okay, Parliament approves the allocation. 2, that clause 2 is vesting a discretion in the minister, approved by the minister.
Yeah.
So you can't read that provision alone. You must read that provision together with Article 296
of
the Constitution.
Which says what?
Which is about discretionary use of power.
Okay.
So it must not, in determining where the source of funding must come from, the minister must not be capricious. The minister might have to publish donations it will accept. For instance, if Odikro, very monitoring our activities, then decides to add the fight against corruption to its remit. In fighting against corruption, somebody somewhere decides, a development partner decides that, look, corruption seriously undermines the rule of law, the confidence in government, trust in government, also stifles the development because money meant for development is channeled into other sources, into private pockets. The Office of Special Prosecutor is doing a good job. Odikro, I want to make a donation. I want to gift some amount of money. 2, I want to gift a vehicle. I want to facilitate the work of the...
But there's not even gift there.
There's gift.
Let's give. Let's give. Look at the clause.
I'm reading. There's no gift.
20.
Donations and grants.
Donations and grants.
There's no gift.
There's no gift. So
There's the one I saw. There's one
there's no
that I
gift.
saw.
Donations and grants.
So he wants to make a grant. So a development partner. A development partner wants to make a donation.
Yes. Forgive me because we've just been joined on live on Skype because of the challenge with the line. I quickly want to get that out of the way so we can come back and continue this. Hello, Nana Kusiwa. Okay, we're having a challenge with the sound. I don't know. Hello, Nana. Can you hear me? Okay. We'll try and fix that, but let me come back to you. You were making a point.
So if it's a grant, it comes from the development partners. Or a donation from a development partner, or even a person. Now, so if the person decides to give to Odikro and says, look, Odikro, monitor the use of this. I want it to actually be applied for the purpose for which it was intended. And the minister approves of it after having published guidelines for the acceptance of donations and grants. If the donation meets the guidelines, the minister approves of the donation, that donation could go to assess the work of the Office of the Special Prosecutor when it finally comes to being. That is the way it is normally done. But we also discovered a third source, and that is international in nature.
Okay.
Hold
that thought.
Yeah.
Let's try again and see if we can reconnect via Skype to Nana Kwesiwa. Hello, Nana.
Hello,
Great.
Evans, can you hear me?
I can hear loud and clear. Thank you very much for connecting. You have a fundamental disagreement with the I guess the two members of the House, the ranking and the chair, as far as the fundamental question we are asking tonight is concerned about whether the office is a democratic necessity or is a duplication, a needless duplication. You say it's a needless duplication. Tell us why.
Well, Evans, why I take that position is simply this. If you look at our laws on corruption, or better put, anti-corruption, you realize that we have quite a great deal of very good legislation which are all engineered at tackling or fighting corruption. Now, specifically, if you look at, let's say, SHRAJ, SHRAJ has the mandate to investigate corruption and deal with it. Now, you have Article 88 as well, which vests prosecutorial powers in the Attorney General. Now, question is, why look at these two powerful institutions which have the mandate to deal with corruption and bypass them to pass another legislation which effectively that office that is being created will be answerable to the Attorney General? That is the question. It makes it needless because in the long run, you are going around and coming back to the same point where the Attorney General forms part of the cabinet of government. And so in effect, you think that you are empowering or you are setting up an office of a special prosecutor to engage in this fight against corruption. But in essence, what you are doing is just beating about the bush. Now, you would realize that with the existing laws on corruption, you have the Auditor General there under the Constitution, Article 187. You have, if you look at the Audit Service Act and all of you have the Public Financial Management laws. All of these legislations are all engineered to tackle corruption. But for the fact that Occupy Ghana went to court, to the Supreme Court, to ensure that the Auditor General makes a move to go after persons who are found culpable by the Auditor General's report over the years to have squandered some money through negligence or through misappropriation or what have you, the Auditor General would not have made that step. And even yesterday, I was reading that members of Parliament are begging the Auditor General not to proceed against certain people. Now, what I realize is that the problem has to do with a lack of political will. That is the problem. It has to do with a lack of political will to fight corruption. However, you would notice that there's rather a groundswell of citizen momentum to fight corruption.
But so, isn't that why maybe we need the Office of the Special Prosecutor? Because once you set that up, then the challenge with political will disappears, because then the person is there just to prosecute. Whether the political powers have the will or not, the office is set up and they will prosecute regardless of the political powers at play.
Unfortunately, Evans, no, because you ask yourself, isn't SHRAJ there? SHRAJ is independent, okay? Even SHRAJ is more independent than the special prosecutor that is being proposed. You understand? Now, if you truly want to make that office independent, I heard arguments, the honorable members of Parliament making argument about financial independence, tenure of office, and all of that. That is important. But so long as Article 88 of our Constitution lives, the special prosecutor will not truly be independent. So you deal, first of all, with Article 88. Look at South Africa. South Africa has something known as the Nzansi. The Nzansi is the local name, but it's called by their constitution, it's called the public protector. And the public protector, look at what happened with Zuma. Zuma was sent to court. Eventually, he has to repay all the sums that he spent to renovate his building, his home, just because of the work of the Mzansi. Do you really think that if the public protector was not truly independent of government, of which Jacob Zuma was the head of government, the public protector could have achieved that? No. Zuma is still president, and yet he has been ordered to refund all those monies he spent to renovate his home.
Now, hold on. Let's talk about that question of independence. That's so fundamental. And Ernest, I'll come to you shortly. But I want to again start with Inusa Fuseni, because funding, we're talking about independence, and Nana Akufo-Addo has even raised that point. The South African example is an apt one because it's on the continent, and we know what the protector did there. And we're talking about the funding. And you were concluding on the donations. Isn't that a problem with the independence? Because if you have this clause of donations, you're going to allow people to control.
It's not a problem. It's not a problem.
You think we should keep donations in?
It's not a problem. But I was saying that there's a third source of funding.
Which
all
is?
over globally, there's a global practice which allows the office, which recovers money from such activities, to keep a portion for the purpose of funding its work. And we as a committee, will be looking at the possibility of
putting that, because I didn't see that in the draft.
in the bill, but it wasn't captured. It's in the
captured.
bill, it was not captured as sources of funding. But Ebuah made a very interesting point. You see, the institutions of state that he has mentioned were in existence at the time His Excellency Nana Akufo-Addo made the promise to the people of Ghana. So it's presumed that the people of Ghana, including Nana Ebuah, knew of the existence of those institutions.
Especially if he voted for Nana.
Yes.
I still voted for him.
Yeah. So now, and the Attorney General had the functions. Occupy Ghana did not go to invent any function.
And by the way, Nana, are you still with Occupy Ghana?
Unfortunately, no. I am not with. I'm no longer with Occupy Ghana.
So you are just private legal practitioner.
I'm with the Citizen Ghana movement.
Citizen Ghana. Thank you very much. Yes, you're making a point.
Another way is talking about Article 1877.
Okay.
Which is part of the Constitution, but the Auditor General refused, or neglected to give effect to his own powers as captured in 187. That means that there was some laxity in the performance of the duties of the Attorney General. Equally, we can talk about the IOCO and the arguments made by Chairman. The tendency of public office holders to interfere in investigations affecting them, especially when they are in power.
Yeah.
Now, but that is not to say that the decision to appoint a person to be solely responsible for unearthing corruption cases and prosecuting same cannot go in tandem with the existence of an Attorney General. What you just need to do is to insulate, to put provisions in law that will insulate
the special prosecutor.
Yes.
But there's nothing in this bill that protects the special prosecutor.
Well,
nothing.
so a lot of things have come up. For instance, one argument that has been made, and made forcefully when we had a stakeholders engagement, was that indeed the power of the appointment of the Attorney General, of the Special Prosecutor, should be exercised under Article 88(4) and not under the Public Office Holders Act, Article 195.
Please break it down for what is it that these acts provisions say?
Now, 88(4) gives the Attorney General exclusive executive authority in appointing somebody to prosecute criminal offenses in the name of the state.
Okay. So in other words, allow the AG to do the appointment.
So one argument is that don't allow the president to appoint.
Okay.
And indeed, in appointing the office of the special prosecutor, 195, which deals with appointment of public officers, doesn't have to be invoked. And 195 says, 195, that's appointment of public officers.
Okay.
So one argument is saying that don't treat the appointment of the special prosecutor under the 195. Give the executive, so because he who appoints fires, can fire. You can hire and fire. And that is why in the United States of America, the practice is for the Attorney General to appoint the special prosecutor on a need-to basis. Yeah. And you know, in the Nixon case, tremendous pressure was brought to bear on the Attorney General to fire the special prosecutor. Now, because there is the special prosecutor in America is special counsel, the special counsel is insulated. The Attorney General could not fire. He had to resign. He had to resign. And so we say that it's possible. Look at in crafting and in designing this institution to fashion out provisions that will insulate a special prosecutor to be appointed subsequently from one, interference from the highest authority, that's the presidency, and from interference from the Attorney General.
Ernest.
Yes, I just want to ask a couple of questions in relation to the funding of the special prosecutor. So, honorable members, I want to know the difference between monies approved by Parliament and donations and grants approved by the minister. What do we mean by monies? What are donations? What are grants? Because I didn't see it under Clause 77 as the interpretation. So what exactly does that entail?
Okay, let me react briefly to what Nana said, that the office, the creation of the office is needless. Unlike the IOCO Act, where investigations are done and prosecutions are made on the authority of the Attorney General, it means the Attorney General must give the approval before prosecutions are made. With respect to the office of the special prosecutor, Article 3.
Section 3.
No, Article 3. To investigate and prosecute cases of alleged corruption. So the power to investigate is vested in the office of the special prosecutor. And the power to prosecute is also vested in the special prosecutor. So the special prosecutor does the investigations, and having come up with a finding which has a legitimate basis for prosecution, the special prosecutor will straightforwardly go ahead and prosecute the person, not on the authority of the Attorney General, because that power has already been vested in the office of the special prosecutor.
But afterwards, he must write a report.
No, and yes, that one is there. That is why I'm saying every person must be answerable to another person. And he also raises the point of SHRAJ. The Constitution mandates SHRAJ to investigate. SHRAJ doesn't have the mandate to prosecute.
True.
So when SHRAJ finishes its findings, it sends everything to the Attorney General, who decides when and how to do the prosecution. And we are talking about independence of the special prosecutor. I will look at the independence of the special prosecutor from the way the office of the special prosecutor has been crafted, and the way the special prosecutor can be removed from office upon a stated behavior.
I think for the proposal is the same as
unlike
the High Court judges.
Probably a DC who is hired and fired at the whims and caprice of the president. The removability of the special prosecutor has been crafted in the provision, in the act or in the bill in such a way that it becomes extremely cumbersome and, if like, difficult for the special prosecutor to be removed
just to educate our listeners. So that goes. The procedure you are saying is the same as what is being used against the EC boss, correct?
That's the point.
Just people can relate. So people can relate to what you say.
Yes, that's the point.
We are thinking that we should even adjust the parliamentary. On the petition which we've approved is forwarded to Parliament, and Parliament will decide whether or not to approve of the removal based on a super majoritarian vote.
So what you're saying is that once the president forwards a petition to the CJ, the CJ does the investigation, sees the prima facie, goes ahead to the substantive, determines that the person must go, goes back to the president. The president should bring it to Parliament.
Forwards it to Parliament for Parliament to take a decision.
That's what you're proposing.
Yeah, that's what we're proposing.
That is what
that's
some
interesting.
experts
Well,
are
that's
proposing. That is what some experts are
But
proposing.
is there agreement? Is there consensus?
That is for the committee to decide
Yes,
what
that's what-
the
yeah.
Attorney General when they need.
I think the public will need will need you to agree on that.
Yes.
Ernest, don't you agree?
Because
that will be such an important thing.
as the chairman and the ranking, we can't take a decision right now for the committee.
Yes,
The
yes.
committee will have to take a decision.
But I think personally, the two of you, are you in favor of this proposal?
No, in fact,
You are in favor of the proposal?
No, in fact, the constitution
Because although you are chairman and ranking, you have individual votes.
Yes, I
What I'm saying is
know.
that
I know.
there's-
We need
the proposal, the maker of the proposal quoted the constitution to buttress his point. He said, look, judges of the Superior Court of Judicature, where someone is infirm and unable to perform the functions of his office, and the petition is brought before the president, and it's quite manifest and clear that such a person is unable to perform the functions of his office. After such a determination has been made, the decision as to whether or not to remove him from office will have to be taken by Parliament.
Let me wrap up with another
And I think
question.
he also
Yes.
raises
about the funding.
About the funding.
Yes, because I think that's
when
still
you
the
talk
gray
about
area for me,
monies
honestly.
approved by Parliament, what we mean is that when the budget is read, some monies are allocated to the ministry.
So this is the withdrawal from consolidated fund.
For consolidation.
Yes,
That's it.
exactly. That's the
Okay.
point. So that the money for the special prosecutor will not come from any other source apart from money that will be approved by Parliament, and it will be channeled directly into the fund.
And again, if you're listening, you're wondering, this is your money.
So
your,
that
your
the
money you
special
pay
prosecutor
as
will not have
taxes
to be dependent
will go
on
to
any other institution.
And
So
especially,
I'm willing to pay the prosecutor. So why are you bringing donations?
And especially-
for me, that's my
You see,
point.
for the donations, the point has to be made clear that it depends on the discretion of the Minister for Finance. So that the
nonsense.
Minister
That's
for Finance may
that's-
decide.
that's our problem.
And come, you see, the Minister for Finance may decide that we are not taking any donations from individuals in Ghana. We are not taking any donations of
But that
grants.
is discretion.
I'm coming.
Are we going to have
not
regulations?
taking-
Are we going
we
to
are
have
not taking-
regulations
we are
that
not
will
taking-
govern
Yes, there'll be
that
regulations.
exercise of
How
discretion?
transparent
Yes,
Are we going to have
regulations.
would that be? Would it
There'll be
publish
regulations.
donations and grants to the
There'll be
special
regulations.
to be published?
what I'm saying is
But
that
because see, Enos Afuseni and the chairman, the ranking, you agree on this. So let me ask you. If I am a business guy, and remember that the prosecutor it's not only investigating public officers, private guys as well. So that's where the problem is. And I have a business. And I know that I've done some shady deals. That may be a subject of investigation. Don't you think I'll find some $100,000 and go and donate to the man, to the institution, through the finance minister? And he approves because he doesn't anticipate.
You see,
but I know what I've done. I'm going to finish my example.
Evans, I've not done anything.
And he approves, tells the service that Evans Mensah brought $100,000 for you for your office. I've approved it. It's in your account. And then 3 months down the line, the man discovers that this individual isn't that compromising his ability to probe me. It will.
It doesn't.
It does.
You see, when we talk about corruption, fighting a corruption, and corruption-related matters, it requires somebody who has the integrity and the courage to stand against a corruption. And I think Nanado has manifestly demonstrated.
No, we're moving
I'm
beyond
coming.
Nanado.
Yeah, I'm coming. Okay. I got it.
There's no evidence yet.
Okay, Mister, you let me land. So the point I'm trying to make here is that even if we delete donations and grants, if the special prosecutor is not one that has the integrity and courage, somebody can even go behind the law and bribe the special prosecutor in the comfort of his house. So first of all, integrity and courage of the special prosecutor is of paramount importance.
Forgive me, I need to wrap up with another question. You want a few minutes?
Briefly.
Yes.
I mean, that's why. I mean, we know that these are issues, these are concerns, and the questions raised on if we want the integrity or the usefulness of those provisions in terms of our ability to fight corruption.
Yeah.
That's why some members have also raised that in promulgating this bill into law, the Attorney General must endeavor to bring along with the bill regulations. Good. So you don't have the opportunity to design regulations after the bill and design the regulations in such a way that you would you'll be able to, like clause 3.4, bring in something which clearly is unacceptable to the people of Ghana.
Okay.
So clearly, people are thinking about around it.
Okay.
But if the Minister of Finance, for instance, publishes regulations and says that, look, we are going to accept these kinds of donations, that puts you on notice.
Yeah, it's clear.
It's clear.
Yeah. Okay, let me wrap up with Nana Kwesi Wise on the line. Hello, Nana. Is still with us on Skype?
Yes.
Are you convinced?
Evan.
Are you convinced now based on the responses you received to your...
No, I am not convinced. In fact, the question we should be asking ourselves is that what is the guarantee that the office of the special prosecutor will not suffer the same fate as Shraj? Would not be as dormant as Shraj. There's no guarantee, absolutely none. Now, I made reference to Article 88 of the Constitution, which vests all prosecutorial powers in the Attorney General. Now, per the provisions of the Special Prosecutor Bill, what is happening is that the Attorney General will be delegating part of those prosecutorial powers to the Special Prosecutor. An act of Parliament cannot give power to another person or body higher than what the Constitution has granted. So no matter how or the power that is delegated to the special prosecutor, the Attorney General reserves the sole constitutional mandate and right to prosecute offenses in this country. That is one. So to actually make the special prosecutor independent, it is important to deal with the problem of Article 88. Now, for me, what would also be truly revolutionary would be to empower citizens to prosecute corruption. If you take the US, for example, there is something known as the Lincoln's Law. The Lincoln's Law, this is how it works. If you're a private citizen, you know of corruption going on. The Lincoln's Law empowers you to embark on prosecution of such cases. Now, there is an incentive in there. You're entitled to a certain percentage of whatever sums you are successfully able to save the state as a result of that prosecution. So we've been fighting corruption through the angle of the executive and what have you. I've given two examples. The Lincoln's Law, we also have the example of the Mzansi, the public protector in South Africa. Let's think about these. These are truly revolutionary. Instead of placing the power to fight corruption in the hands of the executive.
Yeah. And thank you very much. And I think that's the fundamental point, that the way the bill has been structured and crafted now, the suggestion is that the president is appointing the person, and of course, the 7-year, secure tenure that he has, but all that may then lead to interference. In fact, when I was reading the bill, I was making several notes of possible interference that could happen. The president is appointing the person. He's writing, he has to respond to the answer to the Attorney General. So I'm grateful that you joined us, Nana, for those great insights there that you've put into this. And listen, we ran a poll, and I want to quickly bring that to you because that is fundamental to the conversation. I want my guests to have a react to that, and people also join us with comments. I want to bring in now my colleague Ernest, who has been working that poll for us. Ernest, so quickly tell me, so in this poll, what question did we ask?
Evan, so we asked the question, is the office of Special Prosecutor a democratic necessity or needless duplication of existing anti-corruption structures? That's the poll we put out there. Now you have to give us A, a needless duplication, or B, a democratic necessity. And so that's the question we put out there. Now, by close of poll 5 p.m., Evans, we had a total of 132 people connecting with us on this poll. 132 people. Now, out of that number, we had 57 representing 43% saying A, it is a needless duplication. Let me take that again. We had 132 people. 57 out of that number representing 43% say A, it is a needless duplication. And we had 75 people out of the total 132 saying
B, it is a democratic necessity, and that represents 57%. And so that is the poll, Evans. We have a majority of the people, 57% saying it is a democratic necessity. Let's do some Facebook now.
And so these are some of the comments that came on the back of the results.
On the back of
and
the
the results
poll,
are
exactly.
interesting. Yeah, you can see the difference is not
so
really.
close.
It's quite close. 57 and 43.
That surely tells you that the debate will continue to rage on.
Absolutely.
Right? And it's true that we have got institutions, and we're trying to create one other institution. As a lawyer, I would say that the institution of Director of Public Prosecutions is there.
All right.
Why we created. So, you know that, but we've gone past there.
Yeah. But I guess maybe more convincing, has to be done. But let's read some of the comments on the back of it.
Let's start with Facebook. This one's from Benjamin Hyde. He says, it's a democratic necessity for the following reasons. One, the existing anti-corruption structures like YOCO and SHRAJ have been compromised. The AGBNI, National Security, and the Police Service can initiate investigations on their own, but are often smeared with political witch hunting. And the reasons above justify its necessity to fight corruption. There are examples in the UK and the US. As long as the office's tenure is protected and its funding relief from executive control, it must be in order. The other good news is that its jurisdiction covers the whole of the Fourth Republic. And he says, great news, definitely for B. Let's go to what Brew says. I think so. We must go for our monies from Mahama and Co. But I also see that civil servants in government are the most corrupt. Not just the politicians. Nanado must act quickly. We need our monies back from everyone. That's from Kwesi Brew. Jonathan Awad says, a needless duplication. What is the Attorney General doing? And that's a very fundamental question.
Yeah, that we've been talking about.
Yes, exactly. The view of Honorable Inusa Hussaini. Let's take some more comments. This one I have here from Jane Fee Lawrence says, this is because the existing one are not doing much. BNI Yoko seems to be too powerful and effective when they are in when there's a change in government. Now their heads are appointed by the president, which gives the executive power to interfere in the mandatory duties given to them by the Constitution.
And I see one on the screen behind you. Henry says, needless duplication, waste of taxpayers' money on useless office creation, whilst the AG can do that work perfectly for all these years. Who does such work? And we had an example in the past in 2001 where the sitting AG prosecuted Malam Issa. And so there's an example there that we should be highlighting rather than saying, yeah, let's move on and set up a whole. That's one view. And you saw what the poll says. So it's not that the conversation people still need a lot of convincing.
Of course, and Evans, let me take this view from WhatsApp. It says, Evans, some of us voted for the president because of the Office of Special Prosecutor.
Yeah.
Another one here says, Evans, we don't need the bill. And how is this bill so important for us since there are already existing institutions to handle the issue of corruption?
And
so
explain again, it had June, July, BA says democratic necessity. I think all the regional capitals must have an office to fast-track investigations and prosecution. And that raises an important point. Decentralizing the office of the personal prosecutor. Is that even being thought about? We'll talk about that. But thank you, Ernest. Thank you for bringing us that poll. We'll continue the conversation very shortly. We'll take a short break and then we'll continue this. Because the question that the last connector raised about having the offices in the regions is so important. If you're wondering why that is, read the Auditor General's report. A bulk of the monies we lose is as a result of district assemblies misusing funds. And so are we thinking about decentralizing that office? That right after this break. And you're still live on Ghana Connect. It's on Joy 99.7 FM. It's on the JoyNews channel, Multi TV. It's also on myjoyonline.com, and we are on social media as well. Follow us. Let me bring in the chairman on the poll results, on some of the concerns you've raised, and the suggestion about what's your take on the way the poll show that the people it's very close, 42 to 47. It's not as wide as you expect. is the audience giving us a sense that maybe because they don't really understand what is happening, it's, and Marcelo, this week when we were talking, people said, what is it? We find it very difficult to even appreciate what the office is. You think maybe that's a problem, that people don't understand, and maybe you have to engage more?
Yes, I think that that explains why we did the stakeholder engagements. And people came and expressed their views. You could tell from the way the experts spoke and civil society groups spoke that in fact, they had read the bill. That is not to conclude that everybody has read the bill. It is also worthy to note that the doors of Parliament are not closed with respect to receiving further memoranda from the public regarding their inputs into the making of the bill or into solidifying the bill and probably passing a law which can stand the test of time. So probably what we need to do, not the committee alone, maybe the AG, the media, will have to embark on more education of the provisions in the bill and the philosophy and the rationale underpinning the creation of the office of the special.
And you have a partner in us, so
but I think that when all said and done, when the committee submits its report to the plenary and the debate commences on the floor of Parliament, a lot more people will appreciate and understand the need and the essence of the creation of the office of the.
Let me ask you that question that came up towards the end, which is important. I haven't thought about it that way, but it mentioned that, what about decentralizing this office? Because we know, if we read the Auditor General's report every year, the bulk of the money we lose is not from the high-profile political corruption. It's really at the districts. Is there any way to factor this in going forward?
This office is a new office. We've just started. We are starting at the top.
Okay.
And there are resource constraints. You have to look at resources. You have to look at persons with the requisite background to embark on a project of this nature. Because if you want to create offices in all the regions and probably extend them to all the districts, you need resources. You need officers, you need vehicles, you need personnel to man the offices, etc., etc. So probably when this office is tested and tried, and it becomes successful, which I think at the end of the day is going to be the president and the attorney general might decide, or the office of the special prosecutor may decide to extend its jurisdiction by establishing officers in the regions and the districts in order to ensure that the office does its work competently and effectively.
Mr. Fusedi,
so that if there is a case, let's say in Tamale, in Tamale, in Tamale, that is my suggestion. I'm coming. In Tamale, in Tamale or Kumasi, that case doesn't have to be brought to Accra for investigation, if you like, and for prosecution.
Evans, you see, in any democratic exercise, inherent in any democratic exercise, is the right of the majority to be wrong. Okay? So the fact that the majority have said it's a democratic necessity doesn't make it right.
Okay.
They're showing that a large number of people agree that this must be done. They can be wrong. And that's why we also have the power to review our decisions. But as members of Parliament, and particularly as members of the Constitutional, Legal and Parliamentary Affairs Committee, steps have been taken to actualize a campaign promise, which has a political leader. And that political leader is His Excellency Nana Akufo-Addo. He's brought it to Parliament. The duty of members of Parliament, and particularly of the committee, is to make sure that this bill is enriched and that the necessary safety safeguards are put in the bill to prevent a perception of witch hunting and to ensure the integrity of the
I was going to
office.
ask you finally, sum up for me the areas in the bill so far that you think needs tweaking.
Appointment.
Okay. You think who must do it?
We think the Attorney General must do it.
Okay.
Okay, appointment of the person is very important. The process of appointment.
Okay.
How is it going to be done? Are we going to wake up one day and hear that
Are you in favor of advertising the post?
advertising, sending them through selection process, interview process, the criteria for somebody to occupy the office must be very clear. And when that person is settled upon, Parliament must take a decision on who becomes the special prosecutor, and it must be by a supermajority decision. That's what we are saying. So you see, you are scaring it's a tall order. Even though you must be conscious of the abuse of the powers of the minority, because to get 75% of members of Parliament voting to approve of a special
Oh, so this will go to the plenary?
Yes, that's what we are saying.
Oh, okay. For a vote?
But we want to build consensus on the office. Okay?
Interesting.
But I'm not in favor of a large prowling special prosecutor's office, because there are takeover provisions. That when the IOCO is investigating an offense, when Shraj is investigating an offense, when the Auditor General has looked at the books, and it appears to the Auditor General that certain things have been done, the Office of Special Prosecutor can take over the matter and investigate same and possibly prosecute. So it will be seriously a duplication of function if we say investigate all offenses. But we are saying that
which offenses is minority proposing that should be given to
corruption offenses?
All corruption.
All corruption offenses.
Because I've heard this thing about, limiting them to petty corruption.
No. Petty, because you see, because we're looking to stop corruption in all its forms.
All forms.
All forms of corruption.
He should investigate.
He should investigate, but he should have the discretion. It is not the Attorney General who should refer. We're saying that the power of referral should not exist in the Attorney General.
I haven't seen it in the bill right now.
No, in the
referral
bill,
is on the bill.
It's not in the bill. Okay. Except that they are saying that on the authority, we need to define what do they mean by bringing prosecutive matters or cases on the authority.
But the bill says that the special prosecutor should not be subject to any authority.
Authority.
So the AG is
after having been appointed, he should not be accepted.
It's cut off.
There is a
It's totally
provision
cut
that states that the prosecutor is answerable to a board.
A board, yeah. The
We are
governing
even
board.
saying
yes.
that the board is another source of interference. Why do you even think of a board?
Yeah. That is Matiamidu's main contention.
Many people are saying that, and the minority also agrees. Why
But
do
if you
think-
look at the
why do you
composition of the
why do
board-
you conceive of the office of a special prosecutor as an establishment of a public office?
Okay. Is that what the thinking behind the
It's a
creation of the
tax
board?
force,
Okay.
sort of. It's an office, a tax force. So you want to go after certain categories of crime, in particularly corruption. So you set up an office, it has the special prosecutor, and particularly moreover, and also a deputy prosecutor and other office staff,
Yeah.
key investigative officers,
Yeah.
key law officers to do the work.
Interesting. Can you respond to all that for me? Because I think now crystallize everything in responding to Mr. Fuseni as we wrap up.
You see, the issue of board is a constitutional issue. Whenever a public office is created,
That is when you conceive of the office as a public office.
you see,
But it is.
No, it is not supposed to be.
it is a public office.
You're not establishing a public office.
No, it is a public office. Okay? You look at the way the office has been crafted. First of all, the office is being made a body corporate, which
Can be
can
sued.
sue and be sued.
Okay.
The body is being given an independent fund. The process of selection and removability, or if like dismissal of the occupant of the office, is being made to a large extent independent in the provision. Do you understand? So you cannot purport to create an office of this nature and say that that office should be subsumed as a division.
Chairman.
Under, I'm coming.
Chairman, you have just established
No, I'm coming.
the
I'm coming.
free SHS Secretariat. Have you conceived it as a public office?
That has not been created by an act of parliament. It's a government policy. It's a policy that is under the Ministry of Education. But this particular one,
you are creating this by act of parliament because Article 88.3 vests exclusive jurisdiction in the AG, and Article 88.4 says that anybody purporting to exercise that power must exercise it in accordance with law.
Yes.
That is why you are doing that.
Yeah, of course.
Yes.
But you see, the way we have decided, to create the office, or to appoint the special prosecutor, is to create an office independent on its own, has financial independence, if like corporate personality, in order that that office can function conveniently, competently, and efficiently.
And we're saying
But
that is
probably.
Now this is the concession.
But probably, what I may side with some of the experts who expressed their views with respect to the office being answerable to the board is where I have a problem.
Yes.
But whatever be the case, the office must be answerable to the board. But what is the circumstances, or how do we circumscribe the answerability of the office to the board? Because once the board has been established to some extent, and the office has been established, there should be some amount of accountability to the board. But accountability or answerability in respect of influencing the special prosecutor to initiate investigations, influencing the special prosecutor to prosecute corruption and corruption-related matters, that is where I have a problem.
Okay.
But
unfortunately, our time is up. Unfortunately, our time is up. So I want him to land so that we can wrap up.
Yes. So that if that provision can be crafted well, so accountability to the board, answerability to the board, how are we circumscribing it?
Okay.
So we're going to put that in with respect of policy matters. Is it with respect to policy matters
or prosecutorial issues,
or prosecutorial, or if you like, investigative matters?
Okay, good. Thank you very much. Do you want to wrap up for 30 seconds?
I'm just saying that.
Time is up.
Why do you embark on the journey to create legal confusion?
What kind of legal confusion?
Okay. So your position is scrap the board?
Yes, because
you can't scrap the board because
that is the Attorney General.
But he said legally it's impossible. You can't do that. Final word. 30 seconds. 30 seconds. I just.
You see, even so this is the reason why we have to open the process. We have to take our time.
So this is what we're going to do. We're going to create more platforms for this discussion because I think we need to engage more. And I'm told this week we are traveling to go and do further. So thank you very much, Ben Abdallah, for coming. We're going to invite you again. Do you have your?
Yes.
Because this thing needs to be drummed home.
We need to.
We're going to invite you again. Thank you very much. Thank you for connecting. My name is Evan Spencer.